Thabiso Tshukudu from Hahn Hahn joins us today. He is a candidate attorney. He joins us here on Legal Talk to discuss dismissal. Maybe you've been dismissed at work and you have some questions, or maybe a colleague or somebody that you know is going through this at the moment. We've got some advice here for you, thanks to Thabiso, that will definitely shed some light on the matter. Let's just quickly firstly welcome Thabiso back to Legal Talk. It's been a while, Thabiso. Welcome back. How's it going?
Well, thank you for the invitation once more, Ian. I am well, thank you, and I hope that you have been well.
Yes, thank you. Welcome back. Now, what is the test for whether a dismissal is fair or not?
The test for fair or unfair dismissal is whether the dismissal was procedurally and substantively fair. Put differently, did the employer follow proper disciplinary procedures, and did the employer have a fair reason for dismissing the employee? And these are two separate inquiries, because you can have a procedurally fair dismissal where the employer followed the right procedure, but before the dismissal, but have a substantively unfair dismissal where the employer's reason for dismissal falls short of the required standard. Let me make an example for you. Last week, the Labour Court in Port Elizabeth reinstated 52 employees who were dismissed in 2021. And the commissioner found in favor of the employees. The employer went to the Labour Court to review the decision of the commissioner, and the Labour Court still found that the employer's dismissal was substantively unfair. So even though he had followed the right procedure, but the reason for dismissing the employees was not fair.
Okay. And do you have any examples of procedural and substantive fairness?
Yes. Procedural fairness involves an employer's process for disciplining an employee for breaching its code of conduct. For example, an employer has to provide a warning before firing the employee. For serious conduct, it can be a written warning. And it needs to be clear how that long that warning is valid for example, 6 months, 1 year in terms of serious misconduct. The employee must be informed of the charges. You can't just be fired, or you can't just show up at a disciplinary hearing without being informed of what the charges are, and you're allowed the time to prepare. The employee must be present at the hearing to present their case. I've heard of a case where someone was arrested, therefore did not show up for work, and the employee called them to come to work. They informed the employee that I'm in prison. Once the case is finished, then I will come back to work. Then they held a hearing in his absence and fired him. When he came out of prison 6 months later, he appealed against that. And in fact, I think it was a CCMA that found in his favor that there's no way, it's not procedurally fair to hold a hearing in the absence of a person who is in fact in detention. So that is procedural fairness. The right also to call witnesses, cross-examine witnesses, even if they are in the employ of the company. And substantive fairness involves the employee breaking a rule that is well known in the workplace and constitutes serious misconduct worthy of a dismissal. Let me make an example for you. There was a case where an employee was fired they were supposed to drink rooibos, I think, and they decided to drink Jacobs, and they were fired for that. So you cannot fire a person simply because they decided that morning they're going to drink rooibos, especially if you have not even explained what the rule is for. But on the other hand as well, there are rules in the workplace where you handle dangerous machinery. But it's a Sunday night, you were drinking, you do a drug test in the morning, and you're found to still be drunk or having taken drugs. That could lead to dismissal.
I can understand the drugs, but the rooibos, I can't understand. It's crazy.
Complex one.
Very, yeah. So, Thabiso, if a dismissal is found to be substantively and procedurally fair, what happens?
If a dismissal is found to be substantively and procedurally fair, then the game is over for the employee. As I've said, these are two separate inquiries, whether the process was procedurally fair and substantively fair. If both of them are found to be fair, then the dismissal is likely to be fair. But however, I must mention that it's not necessarily over for the employee, because they can still review or take the decision of the commissioner for review at the labor court.
And now, on the opposite side, if a dismissal is found to be substantively and procedurally unfair, what award can a commissioner make?
The first prize for the commissioner is reinstatement. That is to be placed in the same position as you were before you were fired. If you were, let's say, a director and your dismissal was unfair procedurally and substantively, you would have to be reinstated as a director in the same position. Unless you don't want the job back. If you don't want the job back, and people have that option. For example, you've suffered so much trauma during this process, you don't want to go back there. Then the employer can make an award for compensation. The compensations, they differ, whether it is unfair dismissal, whether it was unfair labor practice, automatically unfair dismissal, they differ. For example, if it is an unfair dismissal, you can get up to 12 months compensation. But there are certain factors to consider. For example, how long have you been working there, your age, and some other factors that the commissioner will consider. Because when people hear that I was dismissed, they automatically think that they are entitled to 12 months compensation. You can actually get 1 week compensation, depending on how long you have been working there. I was at a CCMA last week, and one of the commissioners was making a remark that even if the other person won, they're likely not going to give them more than 1 month's compensation. Secondly, compensation for unfair labor practice is limited to 12 months. And in the case of automatically unfair dismissal, it's up to 24 months' wages.
Okay. And then the final question for today, Thabiso, is there any recourse to an aggrieved party by the Commissioner's Award?
Yes. So both parties, whether it be the employer or it be the dismissed employee, they have recourse in terms of approaching the labor court in order to review the decision of or the award made by the commissioner. And the test there is whether a reasonable person in the position of the commissioner could come to that same decision. And even if they're not satisfied with, in respect to the labor court's decision, then they can go up to the labor appeals court. So you can go as up as you want, as long as you have the money to sustain the litigation.
Ah, yes, as long as you have the money, hey? Very important. And that's Thabiso from Hahn Hahn Attorneys, shedding some light on dismissal. Thanks so much, Thabiso. Much appreciated. And it was nice talking to you again.
Thank you very much, Ian. I appreciate the opportunity.
Are you or your business in trouble and struggling to find a solution? Call Hahn Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn Hahn Attorneys, Wednesday mornings at 10 on eRadio.